to another episode of The Next Hearing. Today's episode is not another legal discussion. It's a deep dive into the psychology of persuasion at the highest levels of justice. Think about it. What separates a good lawyer from a great one? Is it knowledge of law? Yes, but that's the foundation. The real game is persuasion. The ability to convince a Supreme Court judge that your interpretation of the law is the correct one. We are going to explore the science and strategy behind how the finest lawyer in India persuade Supreme Court judges. Law is not just about the black and white text of the Constitution. It's about how you present your case, how you frame an argument, and most importantly, how you persuade the judge sitting in front of you. Persuasion in the Supreme Court is not just about citing the correct precedents or interpreting statutes. It's a psychological battle, a mind game, and a strategic maneuvering of word, tone, and timing. Today we are going to break down the hidden art of persuasion in the Supreme Court. What makes a Supreme Court judge lean toward one argument over another? How do top lawyers craft their arguments to influence not just reason, but emotions and biases? We will go deep into how Supreme Court judges think and make decisions, psychological techniques used by the best advocates, cognitive biases that influence judicial rulings, the strategic art of framing legal arguments, the role of storytelling and emotion in persuasion, how cases are won in the final moments, the winnings argument strategy, cases that change legal history. This is a masterclass in legal persuasion. Whether you are a young lawyer, an aspiring litigator, or a law student who wants to understand how the Supreme Court operates behind the scenes, this episode is for you. Let's begin. Imagine a Supreme Court judge sitting on the bench, listening to two powerful arguments. One side presents a case that is logically sound, but the other side presents a case that feels inevitable, as if no other ruling is possible. Which one do you think will win? The truth is, judges, no matter how learned or experienced, are humans first and judges second. Their decisions are shaped by multiple layers of reasoning, biases, and external influences. Let's break it down. 1. Judicial philosophy, the lens through which they see the law. Some judges are originalists, meaning they believe in interpreting the Constitution strictly as it was written. Others are progressives who believe the law must evolve with time. This is why in the Kesavananda Bharati case of 1973, where the Supreme Court ruled that Parliament cannot alter the basic structure of the Constitution, the judges were deeply divided. It was a 7:6 ratio split. So if you're a lawyer appearing before the Supreme Court, your first job is to understand the philosophy of judge or the bench you are arguing before. Are they more inclined towards individual rights, or do they emphasize the power of the state? This shapes how you frame your arguments. 2. Precedents and legal consistency, the power of past rulings. Judges prefer stability. They are not eager to disrupt the established legal order unless they have a compelling reason. A great example is the right to privacy case of 2017. The court overturned decades of ruling that said privacy was not a fundamental right, but it did so by linking privacy to constitutional principles rather than making an entirely new argument. So when you are making an argument, the question is, how can you link your case to existing legal principles? 3. Socio-political climate, the unspoken influence judges live in society. They read newspapers, watch the news, and understand public sentiment. For example, the Supreme Court decision in Sabrimala case of 2018, allowing women of menstruating age to enter the temple, was legally sound, but sparked massive protests. Public reaction, while not a formal factor in judicial decisions, can influence the court's approach. In cases involving major political or religious issues, the Supreme Court often takes a cautious approach. Now, let's shift the focus to the advocates, the masters of persuasion. What makes a few advocates different from other lawyers? The answer lies in their understanding of psychology. Let's explore three key techniques they use. 1. Ethos, the credibility factor. The first thing a lawyer must establish is trust. Judges are more likely to believe an advocate who has a reputation for honesty and deep knowledge. This is why senior advocates get more attention. But if you are a young lawyer, how do we build credibility? Here is the secret. Be precise, be well prepared, be respectful. Judges notice advocates who are clear, confident, and concise. 2. Logos, the logical construction of an argument. Supreme Court judges appreciate a well-structured argument. Your case must follow a logical progression, producing the legal principle, explaining its relevance, and then applying it to the facts of your case. In the Triple Clark case of 19, the winning argument was that the practice violated constitutional morality. Rather than just being a religious matter, the lawyers strategically framed it as a fundamental rights issue, making it hard for the court to rule otherwise. 3. Pathos, the emotional appeal. Even in legal arguments, emotion plays a role. In cases of human rights, gender justice, public interest litigation, the best advocates tell a compelling story. The Nevia case was not just about law, it was about justice. The emotional weight of an argument played a major role in securing the death penalty for the convicts. Every seasoned advocate knows this. Supreme Court cases are often won in the final moments. It is not always the complexity of the law, nor the number of precedents cited, that secures a victory. It is how the argument is delivered at the very end. Think of it like the climax of a courtroom drama. The verdict isn't written yet. The judge's mind is not fully made up. In these moments, the advocate has a golden opportunity to leave an indelible mark. So what separates an ordinary closing argument from a winning one? It comes down to three things. 1. The power of the last sentence. Judges remember the final words you say. Let's step into the shoes of a judge for a moment. You have spent hours listening to complex arguments. Their information overload. Now, the final advocate stands up and in the last 2 minutes, they say something that sticks in your mind. That's the power of last sentence. One of India's top lawyers once said in a high-stake case, "Your Lordships, in this decision lies the foundation of India's future constitutional integrity." Notice what he did there. He didn't just talk about the case, he reframed it as a defining moment in history. Judges don't just rule on cases, they shape the legal future of nation. The best advocates make judges feel the weight of their decision. The last sentence should summarize the case in a way that is impossible to ignore. 2. The pause technique. Strategic silences create emphasis. Now, here's a technique that very few people use, but it's extremely powerful. The art of silence. Imagine you are in the courtroom. The advocate is arguing intensely, making a strong point. Then suddenly, they stop talking. The room goes silent for 2 seconds, 3 seconds. The judge looks up. The attention is now entirely on the advocate, and then they drop the final blow of their argument. This is called the pause technique. Why does it work? Because silence creates anticipation. It makes people listen more carefully to the words that come after. If you are an advocate, you can use this when delivering a crucial line. Instead of rushing, let it breathe. Judges process things better when given a moment of stillness. This is why the best advocates speak slowly, deliberately, and with conviction. 3. Reframing the verdict. Making the judge see the larger picture. Supreme Court judges don't just think about the case in front of them. They think about the long-term consequences of their ruling. This is why framing the verdict becomes a game changer. In landmark cases, lawyers don't just argue for their clients, they argue for the future of the Constitution, the country, and the judiciary. Take the Kesavanandi Bharati case in 1973. The case that saved the Indian democracy. The lawyer arguing against Parliament's absolute power didn't just say This amendment is unconstitutional. Instead, he asked the judges, if Parliament can change the constitution completely, what stops them from abolishing fundamental rights tomorrow? That one question reframed the case. It was no longer about a single amendment. It was about the entire future of the democracy in India. This is how cases are won, not by technical arguments, but by showing judges their ruling is a turning point in the history. Now let's talk about one of the most underrated but powerful persuasion techniques in the courts: storytelling. We often think of legal arguments as cold, logical, and full of citations, but the best advocates humanize that cases. Judges are not machines, they are humans, and humans respond to stories. Here is why storytelling is so powerful in the courtroom. 1. The human impact technique. Turning cases into personal stories. Supreme Court judges deal with complex legal doctrines, but at the very heart of every case is a human story. Let's look at the Vishaka case of 1997, which led to workplace sexual harassment laws in India. The legal argument was about women's rights at the workplace, but the winning advocates didn't just cite international treaties. They told the tragic story of Bhavari Devi, a social worker who was gang raped for trying to stop child marriages. They described how the legal system had failed her. They made the court feel her pain. And when the judges saw the human impact, they didn't just rule on the legal issue. They created an entire framework to prevent sexual harassment at workplace. This is why great lawyers don't just cite laws. They tell stories that make laws impersonal. The moral argument strategy. Making judges feel a duty to act. Another technique used in persuasion is the moral argument strategy. This means showing the court that ruling a certain way is not just legally right, it's morally necessary. A great example is the Nirbhaya case of 2012. The legal team didn't just argue that the accused deserved punishment. They framed it as, this case is not just about one girl. This is about whether women in India will ever feel safe again. The country is watching. Will the law stand for justice or will it fail? This emotional appeal made the judges feel the moral responsibility of their decision, and it led to historical legal reforms on sexual assault laws in India. So if you want to persuade a Supreme Court judge, don't just rely on logic. Make them feel that their ruling has a deeper purpose. Now let's look at few examples, cases where persuasion changed legal history. We are going to discuss 3 cases that weren't just legal battles but were movements that reshaped Indian jurisprudence. The key question we will answer is, how were the cases won? What argument made the difference? 1. Keshavananda Bharati case, 1973. The case that saved Indian democracy. Let's go back to 1973. India is in political turmoil. The parliament under Indira Gandhi's government want absolute power to amend the constitution. One side argues, Parliament is supreme, it can change anything. The other side argues, no, there must be limits. Some parts of the constitution are sacred. The Supreme Court was deeply divided. In a 13-judge bench, the ruling came down to 7:6 ratio split. The decisive factor, the winning argument, which was, if Parliament can amend anything, then fundamental rights can be abolished overnight. If this is allowed, democracy will not survive. Thus phrase, basic structure of the constitution was born, and that one ruling protect our democracy forever. 2. Right to privacy case of 2017. How an emotional argument won constitutional battle. Let's go to year 2017. The lawyer argues that privacy is not a fundamental right, but the advocates fighting for privacy don't just argue law, they frame it as a question of human dignity. One lawyer stands up and says, if privacy is not a fundamental right, then tomorrow the government can track every citizen without limits. Do we want a country where the state owns your personal life? That single question changed the course of the case. The Supreme Court ruled that privacy is intrinsic to human dignity and thus a fundamental right. Third, triple talaq case of 19. When framing the argument, won the case. In triple talaq case, one side argued, it's a religious matter. The winning lawyers, however, reframed it as a women's rights issue. They said, this is not about religion. This is about gender equality and the right to live with dignity. Once they framed it that way, it became almost impossible for the court to rule otherwise. This is the power of framing arguments. It can completely change the outcome of a case. What if I told you that the way you present a legal argument is often more important than the argument itself? It's not about what you say, it's about how you frame it. In the Supreme Court, framing can make the difference between a dismissed case and a landmark judgment. Let's break this down into three powerful techniques used by top advocates to frame their arguments strategically. 1. The power of perspective. Reframing a debate. Have you ever noticed how the same set of facts can lead to completely different conclusions based on how they are presented? This is called reframing, a psychological tool used by lawyers to change the way judges perceive a case. Take the famous triple talaq case, Shaira Bano versus Union of India of 2017. The lawyers and conservative groups argued triple talaq is a religious practice and courts should not interfere with religious customs. Now, if the case remained framed as a matter of religious freedom, the court might have hesitated to intervene. But the petitioners, led by strong legal minds, reframed the argument. This is not about religion. This is about gender justice. If women are given constitutional rights, how can a husband unilaterally divorce his wife by saying 3 words? That single shift from a religious debate to a women's rights issue completely changed the court's perception. The result? The Supreme Court declared triple talaq unconstitutional, ruling in favor of gender equality. This is the power of reframing. When an advocate controls how a judge sees the case, they control the outcome. Second, the red line strategy. Drawing a boundary judges can't cross. Judges don't like uncertainty. If an argument makes them feel that ruling a certain way could lead to chaos or unfairness, they will hesitate. That's where the red line strategy comes in. It works like this. An advocate draws an imaginary red line, a boundary that the court must not cross. For example, in the Puttaswamy case, the right to privacy case of 2017, the government argued that privacy is not a fundamental right. The opposing lawyers used a red line strategy by asking, if privacy is not a fundamental right, does that mean government can track every citizen's calls and emails without restriction? Does that mean personal medical records are no longer private? The judges immediately realized that if they ruled against privacy, they would be opening the floodgates for mass surveillance and potential misuse of power. By drawing a red line, the advocates created a scenario where ruling against privacy was simply not an option. This is how you frame an argument in a way that gives the court only one reasonable choice, the one you want them to take. The big picture approach is the third one, making judges see the future impact. Here's something most people don't realize. Supreme Court judges don't just think about the case in front of them. They think about what their ruling means for future generations. Top advocates understand this. Instead of arguing only about the present case, they ask, what precedent will this case set for future courts? What will be the legal system look like 10 or 20 years from now if the ruling goes a certain way? Let's take a case like Kesavananda Bhartiya versus State of Kerala, one of the most important cases in Indian history. The central question was, can Parliament amend any part of the Constitution? even if it destroys fundamental rights. The government argued, yes, Parliament is the supreme. But the opposing lawyers took the big picture approach. They asked, if Parliament can change anything, what stops them from abolishing elections? What stops them from making a Prime Minister all powerful? This argument forced the judges to think beyond just the present case. It made them consider the long-term impact of their decision. And that's why they introduced the basic structured doctrine, a principle that still protects our constitution today. So, the lesson is this. Great advocates don't argue for their client. They argue for the future of the legal system. We have now uncovered the hidden psychology of persuasion. Psychology of persuasion in the Supreme Court. Here's what we have learned today. 1. Judges are influenced by their judicial philosophy, past rulings, and social political climate. 2. The best advocate use ethos, that is credibility, logos, that is logic. 3rd, pathos, emotion to persuade. 3rd, the final movement of a case are crucial. Judges remember the last thing you say. 4. Great arguments are framed in a way that judges cannot ignore. So the next time you see a Supreme Court hearing, don't just listen to the legal point. Watch how the arguments are structured. Because in the Supreme Court, the most powerful tool isn't the law itself, it's how you present it. Until next time, stay sharp, stay strategic, and remember, the best argument is the one that feels inevitable.